the consequence is that, one that group becomes larger,
Yeah.
it affects.
Yes.
So to that extent, you say that consequence will have to be written to the statute.
And future generations. You see, it's very if you absent a machinery. Let's just keep just suspend the submission with regard to that this datum line is bad. Keep that aside. The moment you have a situation where you are recognizing a particular set of people and conferring upon them citizenship automatically, which according to us ought not to be done, what happens as far as the next generation is concerned? So you are actually cementing something which has happened in a illegal manner. So
one more thing which we'll have to bear in mind,
yes,
Mr. Adwan, is that if the legislature, if the parliament were to merely grant amnesty to a group of illegal immigrants, that would be a very different situation.
It would be a different.
It would be a very different situation. But we can't deny the fact that 6A was enacted at a point of time which is deeply connected to our history, namely that India had a very vital role, if I may use that expression, in the creation of Bangladesh, because we were part of the war as much as Bangladesh was.
We were.
The immigration which took place, Parliament seems to have proceeded on the basis that the immigration which took place cannot be regarded purely on the footing of an illegal immigration, but it was something which was really a humanitarian aspect of what the atrocities which were being committed on the population in East Pakistan, which is why India intervened. The war took place, there was a liberation, Bangladesh was created, and therefore this was not just looked at by Parliament from the perspective of an illegal immigration, but something which is deeply interwoven in our own history of conflict and the liberation of Bangladesh. So it seems to have been on that ground. Therefore, we are not
that argument, that submission of your lordship falls completely in my favor, and I am obliged for this observation, because when we examine the cut-off dates, as far as people who have come after the atrocities, as far as Bangladesh is concerned, this extends no protection to them at all. At all. That's why, sorry.
Undoubtedly, therefore, there are two parts of your petition.
Yes, that's correct.
One is section 6A, and the second, as Brother Suryakant, Brother Sundaresh also said, is the failure to implement the law post the 6A.
Yes.
That's a separate issue. But what has been referred to the Constitution bench is the first, namely the validity of 6A. See?
No, but of course the validity of 6A, but assuming 6A is valid, and it's been held to be reasonable, etc., and it survives the Constitution. Sorry.
But first challenge is that 6A itself as a whole should go.
That's my primary challenge.
Chief is trying to is that could it be compartmentalized in a particular way? Could that be? Is it your case? Let us assume that we uphold 6A. What extent the rights can be conferred? It can be now. Can it be? That's why the question is put to you. Whether they can be taken as a citizen per se, giving all rights to them, to much to the detriment of others, or it could be a curtailed right. Think aloud. Just what I say.
Discharge for the day, because this matter now is completely on board.
आपका यहाँ की है ना? I was on the last part, the last
one, population trends in Assam and India.
Brahma Committee report.
Yes, now we are on the.
So I'm just about to conclude that with the last para which I wish to place is on page 2741 of volume 4 and it is para 1.14.
Yes.
What is the date of the Brahma Committee report? 2017, right?
December 20. 30th December 17. Para 1.14. Protection of indigenous people's land rights is linked to solution of the foreigners' issue of Assam, implementation of the Assam Accord 85. At the moment, the gravest threat perceptions of the indigenous people of Assam to the safety and security of their land rights, and in fact of their very identity, comes from the surging, unchecked infiltration from across the Bangladesh borders. Protection of land rights of the indigenous people of Assam is, in fact, inextricably linked to the protection of their identity and the solution of the problem of foreign nationals issue gripping Assam for the last 7 decades of independence. The committee feels and recommends that protection of land rights of indigenous people of Assam pre-envisages implementation of the Assam Accord 1985, that is 1, sealing of the Indo-Bangladesh international borders via Assam, Meghalaya, Tripura and Mizoram for checking fresh arrivals of illegal immigrants, as also for number 2, detection and deportation of the existing foreign nationals by signing a repatriation treaty with Bangladesh government, and further for correction of voters list by deleting the names of the foreigners. In other words, full implementation of the Assam Accord as inescapably to be put on the priority card. So I have relied on this essentially to again indicate the background facts which have been noticed by this particular committee in so far as the various infiltrations, etc. are concerned. Now, the next document that I wish to point out is the 175th report of the Law Commission of India, which you will find in volume 4 at serial number 52, page 3092. So please have a look at this, the context. The Lordship is pleased to go to page 3093. This is the cover letter by the Chairman, Justice B.P. Jeevan Reddy, on 21st September 2000. I am forwarding herewith the 175th report on the Foreigners Amendment Bill 2000. The subject was taken up in pursuance of a reference made by the Government of India on 16 February 1999. Prior to it, certain amendments were mooted. The Foreigners Amendment Bill 1998, introduced by the Rajya Sabha, our Home Minister, Shri L.K. Advani, the Parliamentary Standing Committee on Home Affairs felt that the government should undertake an in-depth study regarding the efficacy of the proposed amendment in checking infiltration of foreigners from across borders. The committee favored a holistic approach in dealing with the acute problem of infiltration. Various suggestions were made before it and included inter alia the desirability of summary trials, setting up of special courts, making grant of bail more difficult, etc. The matter was referred to the Law Commission. The Commission has considered the relevant material, including the reports and views of the states and union territories regarding their experience in the implementation of the provisions of the Foreigners Act 1946 and other cognate statutory enactments. While dealing with the issue, the Commission had to choose between 2 options which were available.
The first was to recommend a comprehensive act repealing the existing legislations and rules and orders, etc. The second option was to recommend amendments to the existing legislative framework. Instead of codifying the entire law concerning the foreigners, the Commission chose the second option of recommending incorporation of new provisions in the Foreigners Act so that it may make it more effective enough to meet the main problem confronted by the country today, namely illegal migration, without interfering with the existing legal framework. The Commission is of the view that the problem of illegal migration from neighboring countries has to be tackled seriously by providing a machinery for the effective and speedy detection of illegal entrants. The function for determination whether the person is an illegal entrant or not is proposed to be entrusted to immigration officers whose orders shall be appealable, etc., etc. Now here, my lords, the point which we are emphasizing, and here your lordship may go straight away to paragraph 3.2.
Which you will find at page 3100. Since the liberation of erstwhile East Pakistan, the influx, 2.1. May I just take your lordships back to paragraph 2.2 for a moment. Where is that? Okay. 2.2 on page 3097. The problem has attained gigantic proportion, as is evident from an estimated population of about 18 million foreigners living unauthorizedly in India. This has aggravated the employment situation and has distorted the electoral rolls in some states. The undesirable activities of foreigners, including smuggling of narcotic drugs, spreading terrorism and other such activities. It is therefore of utmost importance to devise foolproof administrative measures such as border fencing, modernized electronic surveillance system, as well as effective legislation to deal with the menace. The present study is aimed at examining the existing legislation and suggesting appropriate revision to deal with the issue more effectively. Then para 3.2 on page 3100. Since the liberation of erstwhile East Pakistan, the influx of migrants from Bangladesh has remained unabated and has acquired frightening proportions. There is no realistic estimate of these migrants in India. In fact, no census has been carried out to determine their number. According to the Ministry of Home Affairs, the total number of Bangladeshis illegally residing in India is estimated at 15 to 18 million, and every year at least 3.5 lakhs or more people are infiltrating into the country. On the basis of theoretical extrapolations, the number of illegal migrants in border state has been estimated to be 5.4 million in West Bengal, 4 million in Assam, and 0.8 million in Tripura. It is evident that the number of such migrants is highest in the state of West Bengal. These migrants have spread out to other parts of the country. In Maharashtra, their number is estimated at 0.5 million, in Rajasthan 0.5 million, and in Delhi 0.3 million. These figures are mind-boggling and alarming indeed. India, with its own unmanageable population, is hardly in a position, I think, to take upon the additional burden. And please go to para 3.5. One of the major causes of the aggravation of the problem of illegal migration, especially in the border states, has been the crisis of identity and absence of proper mechanism for the identification of illegal migrants. The available legal framework has failed to curb the illegal migration. That apart, the illegal migrants continue to stay in India with impunity on account of rampant corruption in rank and file of the enforcement agencies. One of their prominent destinations is Mumbai. Another cause of illegal migration is the clandestine cross-border trade between India and Bangladesh, which is estimated at $5 billion. This is 3 times more than the official trade. The trade has created a network of agents and middlemen working in connivance with authorities on both sides of the border. Thus, strong vested interests also appear to be behind the illegal migration.
Further, the trade between two countries has the backdrop of cultural and ethnic ties. In most of the cases, the entry of migrants is surreptitious and they easily mingle with the local population due to ethnic, linguistic, religious, and physical similarities. Their identification is extremely difficult. This has resulted in alteration of demographic composition in the border districts of several states. The bordering states have recorded a high rate of population growth. It has been reported that in case of Assam, there is a higher percentage of rate of population growth in comparison to the national average. There is evidence that many of the illegal migrants have acquired ration cards, obtained various jobs, and got enlisted in electoral roles by suppressing their identities with the help of local touts, unscrupulous officials, and politicians. Impact of illegal migration. The illegal migration has strained the country's economy generally and especially of the border states. The illegal influx has assumed dangerous dimensions, affecting the security of the nation as a whole and especially of the northeastern region because of its proximity with Bangladesh. There are reports of large-scale clandestine movement and smuggling of all kinds of articles by such migrants. Local inhabitants of these bordering areas are under constant fear of losing their identity as they have been reduced to a minority in their own state. This has given rise to various movements and violent agitations, especially in the northeastern areas. The problem has economic implications for the local people and security implications for the country as a whole. Then your lordships may see, yes, so these were essentially the paragraphs that I wanted to highlight from the Law Commission's report. Now, the next document is a study which is authored by Dr. Bhupendra Kumar Nath and Professor Dilip C. Nath. And your lordships will find that again in volume 4. Index number is 48.
And it is at page 2708. Bhupendra Kumar Nath and Professor Dilip C. Nath. So this is from the International Journal of Scientific and Research Publications, Volume 2. The citation is at the top. The title of the paper is The Change of Religion and Language, Composition in the State of Assam in Northeast India, a Statistical Analysis since 1951 to 2001. Now, if we just first see the abstract and then I'll read certain portions. The aim of this study is to examine the change of population composition in terms of religion and language in the districts of state of Assam in Northeast India during post-independence period. The analysis is based on district-level census data of Assam during 1951 to 2001. The result shows that the proportion of Muslim population has been rising rapidly in some districts, whereas the Hindu population is declining and losing their share in all districts of Assam. The change of religious composition has been projected by using polynomial curve fitting, and it is found that Hindu and other religion may become a minority in Assam after 2040 in comparison to the combined proportion of Muslim and Christian population. The growth of various language-speaking population is also analyzed, and it is observed that the proportion of Bengali-speaking population is also rapidly rising, but the proportion of Assamese speakers are declining in all the districts of Assam. To investigate the impact of cross-border migration, the growth of the Muslim population in Assam and Bangladesh is also compared in this study. Then, Manoj, I'm reading a few paragraphs. Initially, the introduction. Religion is one of the most basic socio-cultural characteristics of a society. Different people understand and express religious identity in their own way. The growth and decline of populations and changes in the relative balance between various groups of religion within a population play a crucial role in the rise and fall of nations and even civilization. On the other hand, language is the most important medium of human interaction. The demands for more autonomy, separate states based on language, not only challenge and threaten the political stability of a country,
that also very often lead to ethnic conflicts. Northeast India is surrounded by the border of 4 countries, which are Bangladesh, Bhutan, China, and Myanmar. Though they are separated by political boundary, but they have a cultural affinity in both sides of the border. Therefore, it's important for us to know the changing demographic patterns to make an informed judgment about the cross-border migration and strategic pressures that India is likely to face from its neighboring countries in the near future. This paper examined the changing trend of population composition in terms of religion and language in Assam and all districts during the post-independence period. The change of religious composition has been projected by using a polynomial curve fitting. Moreover, to investigate the impact of cross-border migration on religious change, the growth of the Muslim population of Assam and Bangladesh is also compared in this study. The Census Organization of India is the only instrument that collects the individual information of various religions and language. In this study, the religion and language analysis based on district-level census data of Assam during 1951 to 2001, the religion data of Bangladesh from 74 to 2001 has been collected from the publication of the national series, and those details are given. Now, let's down that same column, about 15 or 12 lines from the bottom, right-hand column. It is therefore important to analyze the changing demography of different religious groups in Assam. According to the 2001 census, the various religious groups living in Assam and India respectively are 64.9 and 80.5% Hindu, 30.9% and 13.4% Muslim, 3.7% and 2.3% Christian, and 0.5 and 3.8% other religions. It is seen that the proportion of Muslim population in Assam is significantly higher than that of the country as a whole. Strikingly, Assam occupies a second position after Jammu and Kashmir in terms of the proportion of the Muslim population in the country. It is seen from Table 1 that during 51 to 2001, the Muslim population increased by 6%, whereas the Hindu population declined by 7.2%. The percentage change of Christians and other religion during this period are 1.7 and minus 0.5% respectively. This significantly high growth of Muslim population in the state may
be due to the consequence of large-scale Muslim migration from Bangladesh and also the prevalence of high birth rate. As a consequence of the slow improvement of socio-economic conditions amongst the Hindus, the natural growth rate of the population amongst them has declined to a great extent from this great extent in the state during this period. So far as the growth of population during 51 to 2001 at the district level is concerned, all the districts witnessed a very high growth of Muslim population during the growth of population than the growth of other religions. The proportion of Muslim population in undivided district Kamrup, so-and-so, so-and-so and so-and-so has increased by 6%, 8%, 10% and 7% respectively. But in Lakhimpur, Sibsagar and and NC Hills district, this growth of the Muslim population during 51 to 2001 is only 2%, 1% and 2% respectively. The undivided district of Golpara, Kamrup, Darang and Naugaon are in continuation of the eastern border belt of high Muslim presence and growth. The undivided Kachar district also falls near the border of Bangladesh and showing high Muslim presence and growth. On the other hand, in almost all districts of Assam and in the state as a whole, the Hindu and other religions declined during 1951 to 2001. In a similar way, the percentage decline of Hindu population in so-and-so, so-and-so are 6%, 11%, 10% and 8% respectively. But in Lakhimpur, Sibsagar and and NC Hills district, this decline of the Hindu population during 51 to 2001 is only 2%, 3% and 0.5% respectively. The percentage increase in the Christian population from 51 to 2001 in all the districts are 1 to 2% only, except undivided so-and-so hill, which is 9.1%. A major reason behind the growth of the Christian population in Assam is the intense movement of conversion towards Christianity, The high growth of the Christian population in Assam is mainly due to conversion of scheduled caste and scheduled tribes to Christianity. Table 2 represents the district-wise percentage of religion in all 23 districts of Assam during 71 to 2001. According to the 2001 census, the percentage of Muslim population in some districts like Dhuburi 74.3, Barapeta 59.4, and so on have occupied a dominant position. But out of 23 districts in Assam, the 17 districts are Hindu dominant, whereas the proportion of Hindu population, is more than 50%. 10 minutes, I'm going to skip. And please go to page 2711.
Mr. Dewan,
just the right hand side. Yes,
on this data in this article, the instructive, it covers the entirety of the period. It covers the period which is prior to the Section 6A operation.
You're right.
Which is prior to 1966. It covers 66 to 71, and it covers 71 and thereafter, almost till 2011. Now, we are on the constitutional validity.
Yes.
We will have to see whether the impact of Section 6A was such that between 1966 and 1971, the operation of 6A, to test your argument, led to a radical change in the demographics of the state so as to affect the cultural identity of the state of Assam, because that's the core of the argument. Now, post 71, this article seems to suggest that the increase in the rapid increase in the numbers of a particular community is suggestive of increasing infiltration.
Yeah.
That has to be dealt with, of course, by a very strict enforcement of the law. Insofar as 6A is concerned, 6A is not a question of law enforcement. 6A, we are testing pure validity.
Yes, I agree.
So, in that sense, is there any material to indicate that the impact between 66 and 71, because the migration which took place between 66 and 1971 was directly impacted by a provision like Section 6A. Incidentally, 6A comes on only post 85, post Assam Accord.
That's not really how
so somebody who was coming in between 66 to 71 had no aspiration or expectation that they are going to be granted citizenship. They came in. Now, where is there any material to indicate that this was really affected by 6A?
I would just suggest
the committee, the second committee which you had given us, the report, which was the Brahma Committee report.
The Brahma Committee report.
Para 1.14, the Brahma Committee report, in fact, said that please implement the Assam Accord completely.
Correct.
Because Brahma Committee said, the Brahma Committee didn't say go behind that part of the Assam Accord, which conferred citizenship on that group of people who came between 66 and 71. They are saying implement the other provisions, strict border fencing, detection of foreigners, deportation of foreigners, deletion from the electoral roll, establishment of more tribunals, giving teeth to the purpose of the law to detect illegal infiltration from any other country and deportation of those persons. That is what Brahma Committee. Brahma Committee also doesn't say that go back on the Assam Accord. That is not really the.
I'm not arguing that. It's a political settlement. If someone has a political settlement,
right,
good luck to them, and let's hope that things get settled. But
statute has only implemented the political settlement.
Yes, but it must, the statute, the political settlement gives no immunity to the statute. The statute must follow the test of the constitution. If it is constitutional, your lordships will uphold it. But if it is unconstitutional, equally the court will strike it down. But
to test your argument, there is no material before us to indicate that the impact of granting certain benefits to citizens who came in between 66 and 71 was so great that the demographics or the cultural identity of the state was affected by that the inflow
No,
in those 5 years.
First, there is material, because all of this is that material. But I want another point.
Post 71, you need not labor, because there, in fact, that's your petition, which will, of course, that's the subject matter of the petition, which should be dealt with by the regular bench. On what are the steps which the government is taking to curb illegal infiltration? That is the second limb.
Why 66? Why before 66? What you find from these statistics is that there is a huge number of people who are coming even prior to 1966. Now, the question I ask myself, because your lordship is obviously ahead of the curve, but I am asking myself, why should Assam suffer in this manner? Do you have this for West Bengal? Do you have it for any of the other border states? What is this type of provision which you say that in Assam, if you are there and if you come and infiltrate to Assam, you settle down and you remain over there? I mean, I can understand the uniform law which you have. So keep this political settlement alive. That, of course, everyone must be encouraged to settle their disputes. And if you can have a mediated settlement, nothing like it. But eventually, if you are engrafting a law, then the law has to be first and foremost across the country applicable. Number one, across the country for all states. Number two, surely if the border states form a separate class, then it must apply to all border states. Here what you are doing, and which I am going to show your lordships the effect and impact, is you are encouraging people to stay on in Assam, remain there for a period of 10 years. And why Assam? Why 66 for Assam? Why not for other parts of the country? So what you are doing essentially is, this is invidious discrimination.
There again, the burden will lie on you to show that the extent of the infiltration between 66 and 71 in Assam,
I'm saying 66 itself is bad.
or was comparable to the infiltration in other states.
No, it's not for me to show. I'll just indicate. If I'm not, it's not for me to show. The moment I show, and that is apparent facially on the document or on section 6A, because 6A is applicable only to Assam and no other part. See, this is very important. You are singling out one unit from the entire federation. And you are making a special set of provisions over there, which are destroying my cultural rights and my identity. By heaping me and by protecting people over there, notionally, number one, and thereafter, as your lordships have seen from these figures, on a practical ground reality, where the percentages are just soaring. And then you have a second generation and a third generation. So, I'm sorry, yes.
The initial burden of proof lies on you, because you are challenging constitutional validity.
So the classification itself is bad. I agree.
You must therefore show two things.
Yes.
That so far as Assam is concerned,
Yeah.
for the purpose of determining the quantum of illegal infiltration,
Yeah.
Assam was similarly situated as compared to other states like West Bengal, Tripura, other states, Mizoram, so on and so forth. Second, you have to establish that as a result of 6A.
I read that Law Commission report which gave those figures on the basis of census figures with regard to infiltration or whatever illegal migrants in other states as well.
Assam was much higher. Therefore, Parliament, if the quantum...
No, just have a look. I think West Bengal may be higher. Just have a look at that.
If the impact is greater in a particular state,
Sorry?
Parliament can always choose degrees of evil and then legislate. We've always allowed an under-inclusive legislation by Parliament.
It's not under-inclusive. What you are doing over here. Sorry? Let us see that page. Law Commission.
Well, you should have applied 6A to West Bengal. You should have applied...
No, that's not my argument.
Tripura.
That's not my argument at all. My argument is very simple. I mean, there are several arguments, but one amongst those arguments is with respect to Article 40. And my submission with respect to Article 40 is that we are people. Plus, we are living. I'm a community. That's why I spent a little time reading the description of whom I represent. I represent a large number of communities which have been living in Assam and who are enjoying culture and want to develop and continue to enjoy their culture.
Because
now, sorry.
When we deal with any matter challenging the constitutional validity of a statute, we begin with a presumption of constitutionality.
I think that's
very
fair.
Well settled.
That's fair.
That we also give Parliament the latitude to recognize degrees of evil. Evil in a sense, I'm using it not in a pejorative sense.
Right.
Parliament can identify the degrees of wrongdoing, the degrees of evil, the degrees of the problem which it wants to.
You're right.
Parliament does not have to legislate with respect to everything to legislate with respect to something. Now,
this is far more important, but please, let's just
respect to Assam. You can certainly.
Well, we are not dealing over here with some classification under a taxing statute or something. We are dealing with citizenship. We are dealing with political rights. We are dealing with issues of tremendous importance, not only for the current generation, but for future generations.
Doubtedly, yeah.
And therefore, I believe that there will have to be a very strong justification, which is furnished by the state, by the government, in support of this particular stand. It's not enough to say that, look, I had an Assam Accord, a political settlement, and therefore I have enacted a law. It's not enough to say that. Of course, you had a political. That's a historical fact. We are not countering or disputing that basis. But thereafter, when you make a law, the law has to be, in our respectful submission and understanding, even-handed. And it has to be even-handed. It cannot oppress a certain community or set of communities in the state so as to obliterate their culture. Whereas you ignore it, as your Lordship correctly said, that of course the Parliament may do things in grades, etc. But the effect, when we go into this and when you see this, what's happening over here? You are having your entire demography which is changing along the border states over there. That's number one. That has an economic impact. It has a political impact. It has a social impact. And this is enormous. This is not something which is happening just. And this statutory provision is encouraging. So keep aside everything which is, I am first challenging 66 itself. Where is the question of suddenly sort of waving a wand and says everyone before 1966 is fine without any scrutiny at all? Then, yes. So, yes, my learned friend is right. It's not some sort of exemption under a taxing statute or something like that. This is when we look at the preamble. And when you see the value of fraternity, the fraternity is among citizens. Fraternity at some larger quality, a larger level, maybe some global fraternity, etc. But here the constitutional mandate in the preamble is about fraternity among citizens. And that fraternity among citizens is sought to be destroyed by a statute which steps in and which destroys my community. How is that to be countenanced?
What is the impact of Section 6A per se on the demographics? Unless you indicate to the court that the impact of 6A on the demographics of the state...
it encourages retention.
Is to destroy the cultural demography of...
Yes, it does. But these are the facts.
We have to have data.
But this is the data.
Data, as we said to you,
yeah,
is data which goes on right through to 2011 and 2020.
But that's what
Assam,
I have.
And Assam undoubtedly has a problem. There's no doubt about the fact that there is infiltration, but we are not testing here. The constitutional validity issue is on the cutoff which has been adopted.
No, the scheme. No, that's too narrow. It's on the full scheme of 6A.
The Assam Accord. What did the Assam Accord do? We must understand the Assam Accord.
Yeah.
There was an agitation.
Correct.
By the All Assam Gan Sangram Parishad, by the All Assam Students Union.
Yes.
Their basic grievance was that Assam is being invaded by foreigners, by illegal infiltration.
That is
the government of India is doing nothing about it. All right, that was the core of the students movement in Assam. An accord is arrived at. We are not saying that it is sanctimonious, but what does the accord really say? Even the agitators said, all right, what has happened up to now is fine. What happened until people who came in between 66 and 71, delete them from the electoral roll. We don't want them to vote for 10 years. After 10 years, they will be restored broadly. This was a scheme, provided they are identified.
So that was the bargaining that they agreed to.
That's right. So that even the agitators who were agitating at that, and that was not an isolated movement.
But we are also agitators. We've mentioned.
What was the agitation?
Right.
The agitation essentially was curb the infiltration. The political compromise which was struck was this: those who came before 71, 66 to 71, leave them alone. Now they have assimilated in India. 71 onwards, you have to be absolutely ruthless. Don't allow anybody post 71 to. And Mr. Diwan, you are right. We are not saying your petition is wrong. Your petition highlights a very significant problem that post 71, nothing has been done by successive governments to curb the infiltration. There you are right. But that's not what we're trying to do. That's not an issue of constitutional validity. That is about the enforcement of law.
No, that's assuming the law is valid. That's my second argument. My first and primary argument is this: could you do that? I've indicated in the morning the broad heads under which we are challenging it, etc., which I will come to. But what this is when we see the working of 6A as it stands, keep the implementation aside. Just 6A as it stands, according to us, is there is no justification for this. There may be some. Sorry.
That by making a provision like 6A,
right,
you are encouraging illegal people to come in the hope that one day we will be also given amnesty. That you can say that. Up to that, you can really say that, look, by making an argument like 6A, by making a statute like 6A, you're holding out some sort of an expectation for people that this will be extended in the future. But I don't think that has happened. After 86, has any law been enacted by Parliament that 71 is extended to 81? It's not like those slum dwellers, who constantly get an extension of the cutoff date for regularization.
No, you see the effect. I'll explain that effect. The effect is absolutely devastating, because what has essentially happened is that there's a notional statutory provision which is there, but the whole situation remains on the ground. That's why we read those portions and the riots, etc. Right until the filing of this petition, we have documented what has happened over there. And the violence which is taking place is also because people are finding.
You're right. The impact is very severe. I mean, that your data subject to hearing.
Yes, and we are going. Yes, we are.
Indicates that we are not. Therefore, please don't get it wrong. We are not belittling what has been said in these reports, like the Law Commission, the Brahma Committee report. These are official committees, no doubt about it. But we are only on this that the answer is very different. The answer, in fact, perhaps your petition, which has been lying for the last 8 years, pending reference, if this reference was not made, the court would have passed a series of orders for enforcing the law in this petition. But this reference, in fact, preempted the court from passing those orders.
No, it didn't preempt. The division bench retained session of the matter and continued to pass directives. But anyway, so let me just complete the groundwork now, because that's extremely important, because factually, as your Lordship correctly says, that this is really a pressing issue on the ground over there. Then as to whether I will, of course, naturally, once I complete the groundwork, go to the statutory elements, the constitutional elements. But please go to page 2711 for a moment.
Yes, please just have a look at the right-hand column. Right-hand column loads about 6 or 7 lines up, from the foot of that table. You will find table 3. It's talking now about languages. So please just see, table 3 represents the details of language groups. Table 4 represents the district-wise percentage of language during 51 to 2001. The area considered undivided 9 districts of Assam in 1951. It is observed from table 4 that the percentage increase in Bengali speaking population is inordinately high than all the other groups of language. During 51 to 2001, the percentage of Bengali speaking population has increased by 6% from 21.2% to 27.5%. But during these periods, the proportion of Assamese speaking people in Assam had declined by 9%. From 69.3% to 60.8%. The percentage change of Hindi, Nepali, and other language-speaking people is only 1 to 2%. Then it goes into further details. Now, just please have a look at the next page, which is 2712, right-hand column. Due to the historical links, geographical and physical proximity of migrants of the Northeast India are mainly from Bangladesh. The state of Assam has 262-kilometer border with Bangladesh. Out of the 92 kilometers is riverine. Therefore, migration from Bangladesh to Assam is much easier. Since Bangladesh is a Muslim-dominant country, therefore, to know the impact of cross-border migration on religious change, it is essential for us to compare the growth of Muslim population on both sides of the border. In Bangladesh, the average annual growth in per 1,000 Muslim population during 74 to 91 and 91 to 2001 are 29.1%, 29.1 and 18.7 respectively. But corresponding Muslim, sorry.
This actually gives
You see, I'm just placing this thought, sorry. This will go to the doctor only.
Table 4 in that, there's something very interesting in table 4.
Yes, table 4. I have it here.
You know, if you see the, I'll thank my learned brother Justice Manoj Mishra for pointing it out to me actually. Manoj, with your permission, I'll just share it. 1951, see the Bengali population is 21.2, dips to 18.561. 18.5%.
Your Lordship is Bengali population.
Bengali
Yes.
population.
Right, 1951, 21.2.
Then dips to 18.5. 71 increases to 19.7. And then see what happens. 91 becomes 21.7% and 2001, 27.5%. So it must be that that is the critical part, the critical period where the demographics really change.
This
is a percentage.
Look at Assamese, 5169.3 keeps on being constant around the same 70, 69.4 and then 60.8 in 2001.
Small says.
So the problem which you are referring to seems to have occurred between the decade of 1991 to 2001. You really see the
Bengal has increased.
This is not necessarily
thing. Between 91 and 2001, the Assamese percentage of population has reduced from 69.4.
This is linguistic.
Linguistic.
Language.
Language. Assamese linguistic population in Assam has reduced from 69.4 to 60.8%.
Yeah.
Over the same period, the Bengali speaking population increases from 21.7 to 27.5.
Yeah.
So the critical decade really in that sense has been 1991 to 2001.
No, but that is because of the Intune provision. And I'll tell you why. Because
why do you say that? That's an area where I'm, frankly, not able to get your.
No, I'll just.
You may be right. If you can.
No, I'm just indicating 2 points, and I'll develop them. But I'm just planting this. Just consider it, because I think all these issues have to be rolled around in one's head, and different thoughts will strike you. The first point I want to make is that if you are giving legitimacy or citizenship, this is a huge thing, citizenship to somebody who has entered at a particular point of time, then, and you are recognizing and protecting, I think it's reasonable to expect that those people will also have children. And you will have a multiplier effect, therefore, in subsequent decades, etc., so therefore, you are at inception, you are allowing somebody in, but the multiplier impact may take place subsequently. That's why your lordships have seen those other tables which I've also referred to, where the population, not just language, because this is the linguistic thing, but the populations themselves increase. And it's likely that the future decadal language will be the language which is primarily spoken by the parents. It's possible. I think it's reasonable to infer that. That's the normal course which is likely to happen. So that's one aspect I want you to just consider. I'll then complete this table. The second point I want your lordships to just consider is that please look at it. We are concerned as writ petitioners with our rights, etc., for sure. However, look at the manner in which the statute operates. If you are someone illegal who has entered into another border state from the very same jurisdiction, you enjoy no protection at all. You enjoy no protection. So, because there's a historical fact which I am not disputing regarding an agitation, there is a whole set of rights and entitlements all the way up to citizenship. I can understand, as was being suggested, that you have some intermediate right for people who have come during a particular period. But it must and ought to fall short of citizenship is what my primary concern is. Because otherwise, my land will go, and is going and has gone to a great extent, economic impacts, cultural impacts, and then eventually the political impacts are going to be enormous. So therefore, I just leave you with these 2 thoughts. Number one, in terms of as far as the future generations, progeny, etc. are concerned, and how that might impact as far as the numbers is concerned, the next generation and the generation after that. And yes, which is really part of the effect test. And the second element which I want to point out is that you ought not, you can, of course, you have some flexibility of policy, etc. But the situation here which is obtaining is, from the very same village, 2 people set out. One is an illegal migrant who crosses the Assam border. The other person is an illegal migrant who crosses the West Bengal border. The person who comes into Bengal is conferred citizenship. In Assam, is conferred citizenship under the statute. And look at the impact downstream and for future generations. So anyway, I'm just leaving you with that thought. Let me just complete these tables and some of these findings. So the last part of this paper or study is 2713, left-hand side. And then I'm done with this paper. Then I go to the last set of documents I'm relying on. Please see conclusion, Roman 4 at page 2713, left-hand column. The empirical analysis based on district-level census data shows that the proportion of Muslim and Bengali-speaking population are rapidly rising during 51 to 2001 than other religion and language. This unusual high growth is not only from the natural increase alone. The natural growth rate of Muslims should not have been much difference between Bangladesh and Assam. But the difference in actual rate clearly confirms the migration of Muslims to Assam. The unusual high growth of Muslims and Bengali population in Assam may be due to cross-border illegal Muslim migrants from Bangladesh to Assam. It's a matter of grave concern because if the change of proportion of religious population continues with this trend, then it is possible that the Assamese Hindu becomes a minority in their own state. In present study, from the statistically projected trend, it is found that the Hindu and other religion will become a minority in comparison to the combined proportion of the Muslim and Christian population after 2040, the former governor of Assam, S.K. Sinha, expressed this in his report in 1998 that illegal migrants threaten to reduce Assamese people to a minority to their own state, as happened in Tripura and Sikkim. So this was now I'm done with this particular table. Now the third and the final, or the next and the final document which I want to refer to is a report which your lordships will find is at serial number 51 of the same report, page 2912.
The investigators investigators for the report are also indicated. Cross-border migration in Assam during,
between Assam.
I'm suggesting 2912 of the very same volume 4. And your lordships have a paper titled or a study titled Cross-Border Migration in Assam during 51 to 2011, Process, Magnitude and Socio-Economic Consequences. Perhaps at page 2912. It's at, I think, in the index, it's serial number 51.
Yes, this is Dr. Nandita Saikia and Dr.
Yes, Nandita Saikia and Dr. William Joe. Now, I'll just indicate what I'm going to do here. I'm going to only point out certain sets of conclusions which are for in various chapters of this particular study.
So please turn first to page 2946.
Chapter 2.
Page 2946.
Same report. The study itself, I might just indicate, begins at page 2912 and it goes on till 3091. I'm going to just read certain conclusions which they have got. Now, please see page 2946. This is at the head of chapter 2, Demographic and Socio-Economic Composition of Assam. Key findings for chapter 2. The fertility rate is lower in Assam than in India, and the mortality rate is higher, but the population growth over 2011 to 1991 is substantially higher in Assam than in India. In comparison to India, the percentage of urban population is nearly half in Assam, and the infant and adult mortality rates higher. Percentage share of Muslim population has been increasing from 25.37% in 1951 to 34.23% in 2011. Among 8 undivided districts of Assam in 1951, 5 districts experienced a sharp increase in Muslim population. Assam and India have a similar literacy rate. In Assam, demographic indicators vary widely by religion, caste, and district. Population density varies widely and is higher in Muslim-dominated districts. Muslims have a higher fertility and mortality rate than Hindus in Assam. Next, please go to page 2961.
Thinking.
I was requesting the court to turn to page 2961. Page 2961, chapter 3, correct?
Yes.
Trends in immigration in Assam, 1951 to 2001. Evidence from direct and indirect demographic estimation. Now, their key findings are, both direct and indirect estimates reveal that Assam is the destination for the migrants, mainly from East Pakistan, Bangladesh, Nepal, and Myanmar, before and after India's independence. On average,
90% of the immigrants in Assam are of Bangladeshi or East Pakistani origin. Census report on immigrants has been substantially underreported in post-Assam movement period. Indirect estimates show, assuming 1951 as the reference period, the number of ever immigrants, these are people who came in after 1951, ever immigrants and their descendants in Assam as high as 4235124 in 2001. In 2001, every sixth individual in Assam is either an immigrant who entered in Assam after 1951 or their descendants. They constitute approximately 15.88% of the total population of Assam in 2001. So this is the effect and impact which this is happening. And of course, it's disproportionate in different districts. Your lordships have already noted that, particularly concentrated in the border districts. And if we are scheduled tribes or even non-scheduled tribe individuals residing in these border districts, the impact and is immense. Now, may I request you to go to page 2985.
Chapter 4. Demographic and socio-economic differentials among natives, old settlers, mixed and immigrant population. Analysis of the primary survey. Key findings of Chapter 4. Immigrant and old settler villages have a younger age structure than native villages. Immigrant villages have a higher share of young population. Thus, young age dependency is more amongst immigrants. Native villages have a higher share of older population. Old age dependency is more amongst natives. Immigrants have more children ever born than natives. Only 44% of the immigrant women have fewer than 2 children, but over 75% of the native women have fewer than 2 children. Also, the perceived ideal number of children is higher amongst immigrants than natives, 65.9 versus 42.7. Similarly, average perceived age at marriage is lower amongst immigrants, immigrant origin women, and native women. Over 96% of the native families report Assamese or other native language as their mother tongue, against 60% of the immigrant families. Over 89% of the natives are Hindus, whereas 97% of the immigrants are Muslims. Among all settlers, 20% are Hindus and 80% are Muslims. Only 31% of the natives, but 99% of the immigrants are of general castes. Over 9% of old settlers are SC. Over 7% of natives have government jobs against 2% of immigrants. Out-migration is higher amongst immigrants, 3.3%, than among natives, where it is 1.6%. The next set of conclusions for Chapter 5, you will find at page 3010. This chapter is titled Magnitude and Dimension of Intergroup Inequalities Between Migrants and Natives. And the key findings. In general, all households in surveyed area have inadequate access to basic amenities. For example, only 20.7% of the households have access to a flush toilet. Only 33.7% have pakka or houses made of solid material, and only 20.3% of the households have clean fuel for cooking. However, relative position of immigrant households was bad. Say only 7.3% of the immigrants' household have a flush toilet, 13.4% have brick houses, and 9.3% use clean fuel for cooking. Despite immigrants less educated than the rest,
registration of births are highest amongst them. The reason of higher birth registration may be the motivation to establish their legality in the current place of residence. So when your lordship examines the effect test, which is a standard manner in which your lordship examines whether a statutory provision is constitutional, not constitutional, or test the validity, this is perhaps a factor which your lordships may also keep in mind. In terms of receiving the government subsidies or government benefits, there exists only marginal differences between native and immigrant households. Say the percentage of households receiving the benefit from government is 34.7% for natives and 31.9% for immigrants. Government beneficiaries were the highest in mixed type of villages, 44.7%, followed by old settlers, 37%. The reproductive span of women belonging to immigrant villages is longer than the rest of women. Knowledge of family planning method is the lowest amongst them. Permanent method of family planning is more popular amongst native women, whereas temporary method appears to be popular amongst immigrant women. When it comes to visiting health workers, a larger percentage of native women visited doctors than immigrant women, 85.3% versus 66.9%, whereas a larger percentage of immigrant women visited LHVs, Lady Health Visitor, or ASHAs. Proxy indicators of quality of service, suggestions received by health workers on healthcare by health workers shows that the quality of service are better in immigrant villages than the native villages.
I'll come to that. Then would your lordships please turn to page... Yes, I'm sorry.
See, it's a general factor.
Yes, I'm sorry.
Anything which is alien would become invasive.
Yeah,
Anything which is invasive will have a far-reaching impact on the native species.
I think
This
you're right.
is a universal phenomenon. Question is one of extent. You take a plant, you take
I see that.
birds, you take animal.
Yeah.
This is a universal phenomenon. The question is the one of impact we have to see. Some will be less invasive, some will be more invasive. You look at it on a broader scale. It is bound to be there.
It is?
It is bound to be there.
No,
The question of one of impact. So we have to look at it now. What extent we can.
It may or may not be there. For example, we have an eastern border and we have a western border. I mean, we have. I'm not suggesting that there are no problems on the western border, but I don't think this issue is arising on our western border. Just keep it. I'm responding only to the observation made by the court. So I don't think there's an inevitability, particularly having regard to the fact that at the end of the day, what Section 6A does is citizenship.
Can you say something from your point of view? Therefore, the stricter scrutiny may be required at times.
Yes,
so the need for we have to look at it in a larger
I commend a strict scrutiny test over here, a very strict scrutiny test for a variety of reasons. First, because what we are receiving at the end of it, which is citizenship. Secondly, the fact that, I mean, I'm not using the word discrimination at this point, but I'm just suggesting to the court that there is certainly differential treatment between Assam and other states. I've given that example of the same individual crossing into two states, etc. So we'll come to that. I mean, those will be important issues. But just responding to your lordship's point, I think there are a likelihood of a range of responses from the state with regard to what can be done if there is a large migrant population which goes across an international border. Our objection, which is confined in this writ petition, is whether this statutory response by the legislature can really withstand constitutional scrutiny. Yes, there are many dimensions, including, of course, elements of proportionality, etc., which will come in. But that's basically, I'm not for a moment suggesting that we want to change or turn the clock back, etc. in terms. Can you grant citizenship? Ultimately, and are you going to allow, I see what the Chief Justice has observed, that look, maybe the fix really which is needed is not assailing a constitutional provision, but ensuring that there is better implementation of the Assam Accord. I'm not for a moment suggesting that ought not to be done. But ultimately, at least for our purposes, whether this type of a statutory scheme is really valid and sustainable, having regard to look at the impacts, Manoj, on this community and on the citizens who have been lawful citizens residing within the state. I mean, the impacts are just completely cutting across economics, politics, culture. And now please go to page chapter 6, conclusions on page 3032.
This is the last set of conclusions. We see chapter 6, 3032, correct? Now, this is landowning pattern, use and transaction of natives and immigrants. Key findings: 94.95% of people belonging to immigrant villages own land, although size of holdings is relatively smaller than natives. The total amount of land possessed by Assamese exclusively speakers was less than that owned by speakers of Bengali and other native languages. 263 bighas versus 489 bighas. Other native language speakers have highest amount of land, 2203 bighas. The average size of holdings are small among Muslims because of bigger population size. The total land possessed by Hindu and Muslim communities is almost equal. Selling land is common amongst native people compared to immigrant or immigrant origin people. Reasons for selling land amongst native includes religious and cultural ceremonies and out-of-pocket expenditure in health. People from immigrant origin offer several times higher prices for land purchase. Financial source for land buying are deposit, pooling money amongst relatives, remittance from out migrants. So these are, Manoj, our essential, sorry. Which page? May I just ask the court to turn to page 3047. Para 6.5. This is on the aspect of land. Please see discussion and conclusion at 3047. The process of illegal immigration poses a particularly high risk to the state of Assam. It may be possible that immigrants and descendants of immigrants will outnumber the indigenous population, and in the next 30 years, and even the local Assamese population will be reduced to a minority. This has created a fear among the indigenous people that they will lose their identity in their own land, writes Kumar in 2016. The fear is twofold. One, with accelerated immigration and their natural expansion, land is becoming scarce. And two, lack of vigilance against illegal occupation of government land, forest reserves, deforestation, grazing, and tribal land encroachments, and so on. Scarcity in turn is instrumental enough to raise land price manifold. This, coupled with a simultaneous becoming poor of the natives and rich of the immigrants, is tilting the purchasing power towards the latter. As the process matures, it leads to accumulation on the part of immigrants and dispossession on those of natives. Land which is intrinsic to a community and an individual's identity, and it is something that holds most dear to oneself and fears the loss of. However, when the loss expands to the level of a community, one can apprehend dangers of cultural loss as well. Assam is undergoing a situation where the natives are on verge of losing out on their native lands, so much so that they are deciding to leave the state. These spell fears of complete replacement of a societal level and drain of indigenous culture. The problems are thus extremely grave and need immediate attention. Land requires immediate constitutional protection. If controlling immigration is not an immediate possibility, also it is instantly important to take note of an action against the illegal land dealings. It is also important to understand the reasons behind compulsions that are making natives leave their homes. This is because native out-migration
is directly making more space for immigrants in Assam. And then there are other, so this is, now this is the, as far as the present writ petitioner is concerned, there's a couple of tables I'll just take you to. But as far as the present writ petitioner is concerned, this is the material we have placed. Because my learned friends have other material also, which they'll place culled out from census reports, etc. Now, if your lordship would just have a look, which is okay. Yes, yes.
If your lordship just goes to page 2949. Just a minute.
Page?
2949.
What document is this?
Same document, right? These two. Yeah. Your lordships are on page 2949. There is a table 2.1. What's the foot? Population trend of Assam and India, 1901 to 2011. So 1951. If your lordship sees the right-hand side, the exponential growth rate in these two, the decadal It's not possible.
Solicitor, if you can tell us, not right now, you'll require official data, how many people actually got the benefit?
I have already, we are working on it. During 66 to 71.
Actually, it was up to 2013. If you see the Rule 19, which was made under the Citizenship Rules 2009, if you have the same book, part 4, at page 25, just see page 25.
Yes, Rule 19, you're not sure.
Rule 19 of the Citizenship Rules
Yes,
2000.
I have Rule 19.
The central government, just read that.
The central government may, for the purpose of subsection 3 of section 6A, appoint an officer not below the rank of additional district magistrate as the registering authority for every district of the state of Assam. An application for registration under subsection 3, this seems to have come in 13.
Right.
Subsection 3 of section 6A shall be made in form number so-and-so by the person to the registering authority for the district in which such person is ordinarily a resident within a period of 30 days from the date of receipt of order of the Foreigners Tribunal declaring such person as a foreigner, provided that the registering authority may, for reasons to be recorded in writing, extend the said period to such further period as may be justified, in each case by not exceeding 60 days. Then 2A, inserted again 13, a person who has been declared as a foreigner by the Foreigners Tribunal
prior to 16 July 2013 and has not been registered under subsection 3 of section 6A for the reason of non-receipt of order of foreigners tribunal or refusal by registering authority to register such person as a foreigner on account of delay, may, within a period of 30 days from the date of receipt of the order passed by the tribunal or from the date of publication of this notification, make an application for registration in form number so-and-so to the registering authority of the district in which such person is ordinarily a resident, provided that the registering authority may, for reasons to be recorded in writing, extend the said period to the not exceeding.
So it was basically the outer limit was 16 July 2013 plus 180 days.
Correct.
Right? So how many people took citizenship in pursuance of this provision?
During this period, but applying Rule 19.
When 6A was in practical operation, 6A is still in force.
Correct.
But the practical operation of 6A comes to an end as we read it around 16th of July 2013.
Correct.
How many people got the benefit of it actually?
That part, we will immediately start working on.
Because if very few people got it, it's a clear indicator that the rest are all illegal immigrants.
Yeah, it's all, nothing is happening.
How many people actually got the benefit of this?
I'll be.
Yeah, and got.
We'll be able to get the details. May not be by tomorrow. We'll try our best.
Yes.
But maybe by day after Saturday.
Check with the officers. How are they interpreting this? Has 6A now come to an end completely in the sense, can somebody make an application today and say that, look, give me the benefit of section 6A? Or has that period come to an end on the 16th of July 2013?
I think, it was my reading is it was a transitory provision. So,
and that's why that rule 19.2 says, 6A says that shall make an application to the registering authority in the manner prescribed. Prescribed is prescribed by the rules. And rule takes a cutoff date of 16 July 2013. For those who did not receive the order detecting them to be a foreigner, it just gave them a period of 30 days from the date of that notification dated 16 July 2013. So do we take it now? You may have to look at it carefully.
Well, we will have to.
Right. Is it that now 6A, nobody can take the benefit of section 6A today? Today means after 2013. Nobody can, right? That's what our reading is also, but I mean, but let's the authorities who are implementing the provisions of the Act tell us,
because
because
a statement, it will have to be. And these figures also. They don't need
what happens, suppose that suppose, my learned brother just Suryakant is asking, what happens when when the order of the tribunal detecting a person to be a foreigner is after July 2013.
What is the status of that person?
Can he say that, look,
he would be liable to be deported?
No, he may say that I am entitled to the benefit of 6A.
Provided he has established, because he
provided other conditions are fulfilled. Provided other conditions are fulfilled. Because if you see section 6A, let's go to 6A again.
Operative date would be, his date of entry.
No.
Between 66 to.
No. You see,
not date of
subject to the provisions of subsection 6 and 7, every person of Indian origin. So first thing, you have to be a person of Indian origin.
Your lordships are on 6A?
A3.
Yes.
Every person of Indian origin who A came to Assam on or before 1st of January 1966 but before 25 March 1971 from the specified territory, B has since the date of his entry into Assam been ordinarily resident in Assam, and C has been detected to be a foreigner. So if you are not detected to be a foreigner, you can't. Then he shall register himself in accordance with the rules made by the central government in this behalf under section 18 with such authority as may be specified, and if his name is included in any electoral roll for any assembly or parliamentary constituency in force on the date of such detection, his name shall be deleted therefrom. Then
this is subject to 6 and 7, of course.
Now see 4. 4 says a person registered shall have, as from the date on which he has been detected to be a foreigner, till the expiry of a period of 10 years, the same rights and obligations as a citizen of India, including the right to obtain a passport and the obligations connected, but shall not be entitled to have his name included in any electoral roll for any assembly or parliamentary constituency at any time before the expiry of the period of 10 years. So 10 years you were struck off the electoral roll, but otherwise you get all the rights of an Indian citizen. Then what happens after 10 years? Fine. A person registered under subsection 3 shall be deemed to be a citizen of India for all purposes as from the date of the expiry of a period of 10 years from the date on which he has been detected to be a foreigner.
So that is, but he must have entered during that period.
Right.
66 to
So, suppose a person has entered between 66 to 71, but is now detected to be a foreigner today. He can take the benefit of section 6A then.
Yes, Your Lordship.
But then what is the meaning of that rule 19.2?
Let me, my lord.
19.2 operates in a different context.
6A and 19.
See, 19.2 is a different rule. It says a person who has been declared as a foreigner by the Foreigners Tribunal prior to 16 July.
Yes.
So he has been declared to be a foreigner by a tribunal prior to 16 July, but has not been registered for the reason of non-receipt of order of the Foreigners Tribunal or refusal by the registering authority to register such person as a foreigner on account of delay, may within 30 days from the date of receipt of the order passed by the Foreigners Tribunal or from the date of publication of this notification make an application for registration. So what Rule 19.2 did was, if there was an order of the tribunal detecting a person to be a foreigner
You are not aware.
prior to 16 July, but you are not aware, it gave a period of 30 days from the date of this notification to make an application for registration. But this does not cover a situation where a person was not detected to be a foreigner before 16 June 2013 at all. Suppose
Subsection 6 is.
then just see subsection 6 of the rule.
6A.
Then 6A.
Detected to be a foreigner.
Then 6A 6, yeah. 6A 6.
6A3 applied when it's detected to be a
Detected, yeah. That's a condition.
That's the condition. There is declared to be a foreigner.
It's an ongoing
There's a
process.
difference between detection and declaration. The commissioner will say, I don't think he's
The only effect will be the person who is
Declaration.
declared, who is detected as a foreigner, say after 16 July 23.
yeah.
He will have to apply for registration within the time limit given under Rule 19.2.
That's correct.
The benefit of extended time will be available under 2A only if he is declared before 19th
For
of
16,
Yes.
19 June 2013.
That seems to be. And detection
So-
is different, declaration is by the tribunal. That's
So basically, we have to now find out from the authorities how many people were detected to be foreigners before 19 June 2013.
And my lord, I would
Right?
also like to see, my lord, for your lordship's
16
assessment,
July 2013.
why, my lord, this 13th amendment came, 2013.
Why did it come exactly?
That the object, my lord, or there must be something, my lord, in the file. Why did this come, my lord? Maybe because there were people who were declared by the Foreigners Tribunal, but they were evading the service of order.
Or was it the idea that, look, 16 July 2013 is now the cut-off.
Yes.
Assam, we've given 15 plus 13, 28 years to implement the Assam Accord. Now no further,
No benefit of 6A. Lord, I'll not call for the files today itself. Your lordship's query is very pertinent. We must answer.
Yes, Mr. Dewan.
Yeah, so I just wanted to point out a page, then I'll go straight to the Constitution and then the statute. I was pointing out table 2.1 at page 2949.
Yes. 2.1.
2.1.
That would be 2947.
Yes, this just may have a few
The fertility rate.
population trend in Assam and India, 1901 to 2011. Is that that what your lordships have? This is volume 4, which I was on.
Population trend of Assam and India.
Yes.
This is from the Dr. Nandita Sekia and Dr. William Job report. And this may have some figures because it has 51, 61, 71, 91, 2001 and 2011 with regard to the Assam population as well as the India population, the decadal variation, and under the heading exponential growth rate of Assam and India, where
actually, if you see the last two columns,
yes,
61 to 71,
yes,
the Assam population grew at the rate of 3.0% and 2.997%.
that's right.
The Indian rate of growth was 1.959 and 2.215%.
Yes.
So during that decade, 1961 to 71, the rate of growth of population as Assam was much higher than the Indian population rate of growth. But then it dips.
Yes,
then it comes to 2.1, then 1.73, 1.576.
So yes, so you'll have noticed there is a gap that in 1981 there is nothing, but of no census 81. So that is 20 years that they've taken. But
now the Assam rate of growth is much lower than the national rate of growth.
yes, it is relatively. You're right. Exponential growth has it is lower than the national rate of growth at this point of time.
Before 61 also, the Assam rate of growth was much higher than the Indian rate of growth.
Yes.
1.8%, whereas the Indian rate of growth was 1, 1.3, 1.2.
Yes.
Minus 0.031.
Of these states, which your lordships are not taking into account.
It was much bigger.
Oh, it was much bigger.
It was divided then. That's why these figures were different.
so this is I thought this table might just be of some assistance because your lordships had asked a question.
Mr. Advocate General, when did the actual reconstitution of Assam take place?
1971.
71 what? What happened 71, 72?
Few states were created, Meghalaya went on.
Meghalaya went off.
Then Mizoram, Arunachal also went on.
New states were created, reorganization of the states. Between that 2 years period.
71 to...
Yes, and Nagaland was earlier.
When did it happen? Oh, Nagaland was earlier.
1962 was Nagaland.
First it broke away from Assam.
No.
I mean, in the sense a new state was created.
Yes.
First a UT, I think, and then a state.
Then Arunachal was a union territory, then Mizoram was an union territory, but they were all bifurcated. They were earlier states, districts of Assam. Like Mizoram was Lusai district.
They were districts. So Mizoram was a district of
District
Assam.
of Assam.
Then what about Arunachal?
Arunachal was Nepal.
Nepal, that's right.
Nepal. So that became a union territory. Now in 85 they became a full-fledged state.
Right.
Tripura went off.
Tripura went off.
Identically, now the high courts are also getting
Right.
Sorry. So may I request you now to just take up the constitution?
Yeah. And kept on, handing over these copies of this constitution to us when the Article 370 hearings were taken place. Yesterday, I was dictating something and I found on page 3 Gopal Shankar Narayan, it's actually edited by him. So that explains why he was very keen to.
Therefore, he kept on.
So Manoj, we are just on the preamble for a moment. So we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens. So I want to just emphasize this notion. Sorry, Justice Sundaresh has the constitution.
What are you reading?
No, I'm just reading the preamble.
Preamble. Very well.
So in the opening phrase, I want to just emphasize to secure to all its citizens. Even before we get into the definition of citizenship, etc., the preamble itself recognizes citizens. Justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and opportunity. Then this next phrase is important. And to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So here I want to just emphasize the expression and to promote among them all fraternity. So I would respectfully submit that this fraternity which we are speaking of, or which the Constitution speaks of in its preamble, is really among the citizens. It's not some sort of a global notion of fraternity of humankind or mankind. Promote among them all, which is the citizens, fraternity, and then the next part is also very important, assuring the dignity of the individual and the unity and integrity of the nation. And this will, of course, take us to that other Sonowal case, etc., which we'll do. But these are so important values in terms of fraternity among citizens and keeping that in the context of unity and integrity of India. Now, please take up part 2, section, Article 5.
Citizenship at the commencement of the Constitution. At the commencement of this Constitution, every person who has his domicile in the territory of India and A, who was born in the territory of India, or either of whose parent was born in the territory of India, or C, who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement, shall be a citizen of India. So Article 5 was brought in to effect under Article 394, or rather by Article 394 on 26th of November 1949. So this is at the commencement of this Constitution. The expression at the commencement of this Constitution in Article 5 would relate, according to us, to 26th November 1949. And then it provides that every person who has his domicile in the territory of India, born in the territory of India, either of whose parents in territory of India, who is ordinarily resident, etc., shall be a citizen of India. Now please see section 6, Article 6, Rights of citizenship of certain persons who have migrated to India from Pakistan. Notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this Constitution if he or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935 as originally enacted, and B1, in case where such person has so migrated before the 19th day of July 1948, he has been ordinarily resident in the territory of India since the date of his migration, or in the case where such person has so migrated on or after the 19th day of July 1948, he has been registered as a citizen of India by an officer appointed in that behalf by the government of the Dominion of India on an application made by him, therefore, to such officer before the commencement of this Constitution in the form and manner prescribed by that government, provided that no person shall be so registered unless he has been a resident in the territory of India for at least 6 months immediately preceding the date of his application. So in Article 6 at this point, I want to emphasize that there is a date which is prescribed in terms of persons who have migrated to India, and that date under the constitutional mandate as we read it is 19th July 1948. Then Article 7 is rights of certain migrants to Pakistan. So with your permission, I'm skipping that. Article 8 is rights of citizenship of certain persons of Indian origin residing outside India. Just a second here now. And please see Article 9. Persons voluntarily acquiring citizenship of a foreign state not to be citizens. No person shall be a citizen of India by virtue of Article 5 or be deemed to be a citizen of India by virtue of Article 6 or Article 8 if he has voluntarily acquired the citizenship of any foreign state. And in this context, you may recall that one of the questions which was also framed in terms of by Justice Nariman was in the context that, look, we don't recognize dual citizenship